Last week, a courtroom in Provo, Utah spent 5 days deciding one thing: whether there's enough evidence to put Tyler Robinson on trial for the murder of Charlie Kirk. I went through the testimony, the evidence, the exhibits, all 5 days to break down what actually happened. I'm Drew Breasy. My real name is Andrew Baxter. I'm a retired police commander with 29 years in law enforcement, investigations, command, and administration. This isn't a recap of headlines. This is a plain English breakdown of what the state presented, what the defense actually got, and what happens now. I'm not an attorney. This isn't legal advice by any stretch. One more thing before we start. Charlie Kirk was a homicide victim, and he has a family who's living with that. This isn't a tribute video, and it's not a conspiracy video. I'm not here to eulogize anybody, and I'm not here to chase theories. This is operational analysis, what the evidence actually was, what held up, what didn't, straight from the record. And if you're looking for either of those other two things, this probably isn't going to be the place for you. I'm going to walk you through the whole hearing by answering 3 major questions. Once you understand the answers to these 3 questions, you'll understand everything that happened this week and actually why it matters. So question 1 is, what exactly was the state's case and how strong is it? Question 2 is, what did the defense actually land? And then, of course, question 3 is, why didn't this end with a ruling? Why did they spend an entire week doing this? So what happens next? So let's start. So for brief context, here's the case in plain terms. On September 10th, 2025, Charlie Kirk was shot and killed while speaking at an event at Utah Valley University. Tyler Robinson was identified through surveillance footage, digital evidence, and DNA. He turned himself in the next day, September 11th, at a sheriff's office in Washington County with his parents and a family friend. Now here's the scope line, because this matters. What happened this week was not a trial. It was not a determination of guilt. It was a preliminary hearing, a probable cause hearing. The only question the court was asked to answer is whether the state has enough evidence to justify a trial and whether that evidence supports the aggravating circumstance tied to the death penalty the state is possibly pursuing. Both sides agree Charlie Kirk was shot and killed. Nobody's disputing that. The disagreement is whether the specific chain of evidence, digital, physical, forensic, is solid enough to send this case forward the way it's charged. So, question 1, the state's case. The answer is yes. The state built a strong case, and here's why that matters. It wasn't one piece of evidence. It was 5 different types of evidence from 5 different sources, all pointing to the same direction. Let's start with the scene.
When I got up there and I could see this disturbance in gravel, to me it looks like a sniper pad, a person that has been laying in a prone position, and you've got markings of elbows, knees, and feet to where somebody was in the line of sight of where Charlie's tent was. The
first officer on that rooftop described a disturbed patch of gravel, what he called a sniper pad, a prone position with the marks of elbows and knees and feet lined up in a direct sight line to where Kirk was speaking. In police work, that's not speculation. That's a documented firing position, and it's the first physical anchor point of the entire case. Next, how do you get from a disturbed patch of gravel to a suspect?
If we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. And they move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area. and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
Surveillance video. That's a full-on investigator narrating campus surveillance in real time. A person goes over the railing onto the rooftop around 12:15, gets into a prone position by 12:22. 12:23, the shot happens. At 12:23 and 28 seconds, the person stands, jumps from the roof, and around 12:24:42, and crosses the Campus Drive into the wooded area, the same wooded area where the murder weapon was later recovered. That's the scene, and that's the suspect connected on video, second by second. Now, the forensics. This is where the case gets its scientific weight.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twigs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
I want you to hear that exact phrasing there because it's precise and it matters. The analyst didn't say this is Robinson's DNA. She said the DNA on the towel is 1.7 octillion times more likely if Twigs and Robinson are the contributors than if Twigs and an unknown, unrelated person are the contributors. The same exact framing on the screwdriver, 30 quintillion times more likely. That's how forensic DNA statistics actually work. It's not necessarily a fingerprint match. It's a probability so large that it actually functions like one. And Twigs, Lance Twigs, is Robinson's roommate. He's also his romantic partner. He matters to this case in a big way because the next piece of evidence comes straight from his phone.
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize. Let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And Then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
If we could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again.
So let me be precise about what you just heard, because that matters also. That's Agent Davis reading a text thread into evidence off of Twig's phone, his own phone, and it was admitted as an exhibit. It's not Twig speaking those words on camera. In that thread, Twig's text, quote, you weren't the one who did it, right? End quote. And Robinson replies, quote, I am. I'm sorry, end quote. In a separate exchange, when Twiggs asks why, Robinson answers, quote, I had enough of his hatred, end quote. That's a confession. It's read into the court record from a text message the state says came directly from Robinson's phone. And the last piece, Robinson turned himself in. The night after the shooting, he drove to a sheriff's office in Washington County with his parents and a family friend and surrendered. Here's what all that means before we move to the defense. Probable cause isn't tested by one strong piece of evidence. It's tested by whether multiple independent sources, a crime scene, a video, a DNA lab, a phone, and the suspect's own actions all point in the same direction. And here they did. Which brings us to question 2, what the defense actually landed. The answer on this one is no, the defense didn't defeat the state's case, but they built a real documented record of gaps. And if this case goes to trial, these are the exact places a jury is going to have to spend time. First, scene security. Stop me if you've heard this.
It appears to end while you're still on the roof. Do you know why that is?
I think the battery went dead. It was just right at that moment.
Okay. And do you know, did you ever turn it back on that day or go get it, I don't know, what do you have to do, charge it or stick a new battery in it? I don't even know.
Usually dock it, but no, I didn't go back. It was too chaotic running around.
So that 27-minute and 35-second body cam that starts when you're at the Hall of Flags and ends while you're still on the roof, but haven't put the crime tape up yet, that's the only body cam you have that day?
Yes.
Only a 27-minute and 35-second body cam exists that day, ending before the crime tape even went up. Here's the problem the defense exposed. The first officer's body camera died while he was still on that rooftop, before he'd even put up crime scene tape. In law enforcement, that's a documented gap in the chain of custody for the earliest, most critical moments at the scene. It doesn't undo the evidence that came later, but it's real. It's an admitted hole in the record. And that goes hand in hand with the second issue, which is what wasn't found. Because there were no spent shell casings. There were no unfired bullets anywhere on or near that rooftop. In the surveillance video the state relied on was too poor in quality to identify a face, a height, a weight, or any kind of clothing detail. The defense didn't dispute that somebody was on the roof. They disputed how much that video by itself actually proves. And that goes hand in hand with the third. This is the strongest moment the defense had all week, the ballistics match. So listen to what she had to say when she was pushed to explain that finding.
I want to ask you, because I'm unclear on what inconclusive mean. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the landing group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see at all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
The bullet fragment recovered from Kirk's body could not be matched to the recovered rifle, and it couldn't be excluded from it either. Her own words, neither enough agreement nor enough disagreement to reach a conclusion either way.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only two individuals because those small peaks, there was nothing left for a third individual to be compared to.
It's not a minor technicality. That's the state's own examiner saying under oath that the physical link between the specific fragment and this specific rifle is unresolved. So fourth is the DNA reversal. Here's the sequence. The analyst originally concluded that there were 3 contributors to a key DNA sample. She later changed that to 2 after she received a comparison sample from Lance Twiggs and was able to account for his DNA in the mix. That's a real documented example of a scientific conclusion shifting after investigators supplied more context. It doesn't mean the science was wrong. It means the defense has something concrete to point to when they argue the process wasn't as clean as the state's report makes it sound.
Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst 2 or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
And finally, the tool mark examiner's own admissions about her methods. Look, that's about as direct as it gets. It's in her own words, her conclusion, and her opinion, and what one examiner calls, quote, sufficient agreement, end quote, between 2 tool marks. Another examiner might judge differently. That's not the defense characterizing her as her work as subjective. That's the examiner saying it herself. That's important. Here's what this means before we move on. Probable cause is a lower bar than proof at trial. If you'll remember, it's proof beyond a reasonable doubt. None of these 5 gaps defeat the state's case on their own, but they are exactly the kind of weaknesses a jury would have to weigh months from now. And the defense put every one of them on the record this week. So that brings us to question number 3. Why no ruling and what happens next? The answer is this. Judge Tony Graf did not rule on probable cause at the end of this hearing. He continued the case. Here's the exact language from the bench. This preliminary hearing is continued until September 1st at 10 a.m. for an in-person hearing, and both sides will submit written legal briefs first and then argue probable cause directly in front of the judge on that date. So I want to be straight with you about why that happens, because a delay like this can look strange if you don't know how it works. Robinson is charged with 10 separate counts, including a capital charge with a death penalty aggravating circumstance attached to it. That's not a simple case to rule on from the bench the moment testimony ends. A judge taking extra time to get a written ruling right on a case this complex isn't a red flag at all. It's actually the system being very, very careful on a case where being careful actually counts. There's one more fact worth knowing. Robinson declined to testify at this hearing. It was on his attorney's advice. That's his right, and it's not unusual at all. The September 1st hearing will not be live streamed. The court has denied electronic media coverage of that date, so you won't be able to watch it the way you watched this week's testimony. Now, where this goes from here. The court's position is this. Judge Graf has taken the complexity of a 10-count capital case seriously enough to want a full briefing before he rules. That is a careful, defensible, whichever way the ruling ultimately goes kind of decision. The state's position is this. They built a strong, stacked case this week, but the inconclusive ballistics match and the DNA methodology questions are real vulnerabilities. Bindover doesn't require those questions to be answered. Trial does. Now, last is the defense's position. They didn't defeat the probable cause, but they built a documented record on the body camera, on the ballistics, on the DNA that's going to matter for trial strategy no matter what happens on September 1st. I turned to the internet to see what the most frequently asked questions were about this hearing. Stick around because I want to answer a few questions that I know people have because they've been searching for them. 1, what is a preliminary hearing and how is it different from a trial? Understand, a preliminary hearing decides whether there's enough evidence, probable cause, to send the case to trial. It doesn't decide guilt or innocence. That question doesn't come until the trial. That question comes in front of a jury. This is enough to have to convince a judge that probable cause exists. Number 2, did Tyler Robinson confess to killing Charlie Kirk? In that text exchange that was read into evidence this week, Robinson's roommate asked him directly if he was the one who did it, and he replied, quote, "I am. I'm sorry," end quote. That text was read into the court record by an investigating agent, not spoken by Robinson on camera. Another highly searched question, who is Lance Twiggs? Lance Twiggs is Robinson's roommate and romantic partner. His phone contained the text exchange central to the state's case, and a redacted interview with him was played in court this week. Another commonly asked question is, could Tyler Robinson get the death penalty? The state is pursuing the death penalty and has tied it to an aggravating circumstance, that the shooting endangered others at the event. That question is still ahead in this case. And another common question that's being searched right now, is Tyler Robinson going to trial? And if so, when? Well, that's not decided yet. The oral arguments on probable cause are scheduled for September 1st at 10 a.m. in front of Judge Graf. As you heard, it's not going to be televised. People want to know why the judge didn't rule at the end of the hearing, and that's because this is a 10-count capital case, and the judge chose to take written briefing before ruling rather than deciding from the bench the moment the testimony ended. It's a good thing for everyone involved. So here's the through line. A 5-day preliminary hearing isn't a formality. It's where a paper case gets tested for the first time, where the state has to show its evidence in open court, and the defense gets its first real shot at what they got. That's the value of going through the whole thing instead of just the highlight clips. Now, do yourself a favor and mark your calendar for September 1st at 10 a.m. That's oral arguments on probable cause. It won't be live streamed, so I'll be here to break it down at the conclusion. I'm Andrew Baxter. This is the Comm Center, where we know that every good true crime story starts with a 911 call. On behalf of my partner, John, thanks for watching.